do have a question for folks who day in, day out are setting up and managing questions and issues around legal fiscal matters within a company or startup. This is a really great time to do that. So we have a mic there, and then we'll do really short questions so we can get a bunch of them in.
Okay. Oh, can you hear me? I'll try to scream because the thing is not working.
1 second. Here you go.
Hello?
Yes.
Perfect. We talked earlier about documents to proactively prevent drama with founders. So in the event that both founders still want part of the company, but they're not going to work together, right? So you can't decide who's going to be able to continue on with the company. What can you do proactively before the company starts to prepare for that?
That's a question. Liz, do you want to take that one?
Yeah, sure. That's a great question because you made a very good point that there are different types of founders, right? There are the founders who are intended to be actively involved in the day-to-day of the business, and then there are other founders who are going to be less involved. There are a number of mechanisms, and none of these are perfect. It really is a case-by-case analysis where you can protect against future disputes. One is a redemption right. And a put right, should the company be permitted to buy back the shares of the founders at a price to be determined, or on the other hand, should a founder be permitted to sell back his or her shares to the company, at a price to be determined either by mutual negotiation, fair market value. There are a number of ways that can be determined. There are things called shotgun buy-sell clauses, where if there is an eventual dispute or deadlock, founders can put their shares against each other. Again, none of these are perfect. Unfortunately, it is a mess when founders struggle. But by thinking about these issues earlier, you can make things a lot cleaner. I have unfortunately a client now who had an early founder who isn't very active, but negotiated very what's called supermajority rights. So he required that to do certain things, approve budgets, raise capital, 75% of the shares needed to vote. Now this guy, this other founder, is holding the company hostage because he won't approve anything because he's not a startup person. He's looking at it through the lens of a traditional business, and he's seeing a lot of expenses. He's seeing a model which is startup trajectory of growth, not a trajectory of growth and expenses for a traditional company, and he's holding the company hostage. So the moral is no supermajority voting rights. Don't create a governance structure where a founder can hold the company hostage. And think about things like redemption rights, put rights, shotgun buy-sell. It's none of it is perfect. So definitely talk to other founders with more experience, your advisors, and a lawyer.
One thing I'd add is because there's a lot of these more complicated provisions, and they're definitely appropriate in situations. But before you have your investors come in, typically you don't have these provisions, and it's a matter of who controls the board, because the board hires and fires. If you control the board, you can fire somebody. So a lot of times if you have 3 founders, it's just there's 3 directors, and if 2 decide that the third's not important or participating, tough luck. And then when the investors come in, we have supermajority provisions and more complicated sections, but ultimately, if they have 2 seats and the founders have 3, well, you can't fire the founders unless the founders go against one another. And occasionally, when you get to a certain stage, if somebody's putting in enough money, it might flip, and now the investors control the board, and that's where you have to worry, and you need to have good vesting provisions and things to protect yourself. But always start with who elects the board, because that's your most important data point.